after Homoglow cleaned our place for $19, we fired our old housekeeper. Homoglow tackled everything, from our kitchen to our bathroom, all our laundry. You just pick a date, pick a cleaner, and enjoy a spotless house for $19.
We're coming together for our yearly service project and running a t-shirt fundraiser through Custom Ink to help the cause. Plus, their design services team helped us get a design we love. Come together for a cause. Get started today at customink.com.
Welcome back. It is 11 a.m. Eastern, 8 a.m. Pacific. I'm Katie Turin for Jose Díaz-Balart. This morning, former President Trump and his legal team are pouncing on the Supreme Court's landmark ruling that he cannot be prosecuted for official acts. Hours after that monumental decision, his attorneys sent a letter to the judge overseeing his New York hush money case, his conviction, using his newly established immunity as grounds to postpone next week's sentencing and then ultimately toss his felony convictions. We'll get into whether that immunity applies in a moment. Meantime, a person familiar tells NBC News special counsel Jack Smith is not, as of now, planning to ask the Supreme Court to move quicker than usual to issue his official judgment, perhaps acknowledging that there is no way before the trial, no way that the trial can happen now before the election. With us, NBC News correspondent Vaughn Hilliard, MSNBC legal correspondent Lisa Rubin, Catherine Christian, a former Manhattan assistant district attorney and an MSNBC legal analyst, and Misty Maris, a defense attorney. All right, Lisa, you have a little bit of news. Please give it to us.
The DA's office is saying, with respect to former President Trump's motion to apply the immunity ruling of yesterday to that conviction in New York, DA's office is saying they don't oppose him taking some time to file a motion which would necessarily adjourn the sentencing. We don't have a ruling yet from Judge Merchan as to whether he's going to put off that July 11th sentencing. But right now we have notice from the DA's office that they're okay with pushing that off and having briefing on President Trump's motion to vacate the verdict on the basis of that immunity ruling.
Why would they, Catherine?
Why would they consent? Because they know that this is an issue that we don't want an appellate issue. That's what the prosecution is thinking. If Merchan said, I'm just not dealing with it, that wouldn't happen. So they want to respond. They want to put it in writing. And I told Misty off air that sentences, at least in New York and state court, are often adjourned, that when there's a date set, it's not always certain, because issues like this, not involving a former president, but issues come up and it's adjourned.
We just got the letter from Donald Trump's team to Juan Merchan. This was sent by, I think, Todd Blanche. Yes, Todd Blanche is the signee. So, Vaughn, tell me about the Trump team and their strategy with using this immunity decision.
Right. The argument that they're making, Donald Trump's attorneys, are the fact that not necessarily that Donald Trump was immune from New York charges that he was found guilty of, but some of the underlying evidence, particularly the tweets and the public statements that were used and brought into as evidence by the district attorney's office to help convince the jury that he was in fact guilty. Because what we have from the Supreme Court's decision was a clear statement, quote, "For these reasons, most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities." So Donald Trump's team is contesting that if in fact the DA's office was not able to bring some of that testimony in, it is not sure that the jury would have found him guilty. And so this is where we now are looking at July 11th was supposed to be the sentencing. That is next Thursday. We now expect that sentencing to be pushed off based off of the request of the Donald Trump's defense team, but now also the DA's office saying they're fine with it, but give us 2 weeks to respond to these motions that they're putting forward.
Let me just read a little bit from the letter. I think it's interesting. This is, again, Todd Blanche writing to Judge Juan Merchan regarding the Trump immunity case and ruling from the Supreme Court. At trial and during summations, DA New York placed highly prejudicial emphasis on official acts evidence, including witness testimony regarding events in the Oval Office that DA New York described as devastating, social media posts during President Trump's first term, and toll records reflecting calls involving President Trump while he was in office. Under Trump, this official acts evidence should never have been put before the jury. Consistent with arguments that were made before and during the trial, the Supreme Court held in Trump that President Trump may not be prosecuted for exercising his core constitutional powers, and he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts. The presumption applies unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. DA New York cannot make that showing here. Moreover, as we argued previously, Trump the case, forbids the use of evidence about such official conduct, even when an indictment alleges only unofficial conduct. This includes, and this is key, President Trump's tweets and public addresses. Tweets and public addresses, Misty.
Yeah, this is what I expected to see in this letter, because what the defense is going to argue is that anything that happened during the time Trump was president is going to fall into one of these two categories where he either has immunity or presumptive immunity. Now, we're not talking about the conduct. It's pretty clear that the conduct that was the subject of this case, the Stormy Daniels, the hush money payment, that's going to be personal. That's going to be outside of this. But they are talking about the evidence that was admitted.
This is the tweets in which Donald Trump is pressuring Michael Cohen. These are the tweets.
Correct. And no, these are...
These are the tweets, among other things, in which Donald Trump is admitting that the payments to Michael Cohen were reimbursements for Stormy Daniels. They also include his Office of Government Ethics filing, in which he also classifies it as a reimbursement.
Right. And so what they're trying to do is say none of this evidence should have ever come into the courtroom. And they're using the recent SCOTUS decision as the basis for that. Or at the very least, the judge has to go back through all of that evidence and look at it through the prism of the new test established by the immunity case.
Will it be successful?
I don't think it will be, because the reason why the prosecutors want to respond, they're going to go through and look at the mountain of evidence that they have, that if you exclude all of the tweets and other evidence that borderline could be considered official, it would still be a guilty verdict. That's what the prosecution is going to argue.
It is an audacious move by Donald Trump's team, but not unexpected.
No, and it's not, I want to say, Katie, while it's bold, I don't think it's frivolous either. The ruling yesterday with respect to evidence is a pretty clear one. This is a motion that they made in the run-up to trial. Judge Merchan told them that they were not only too late, but that his understanding of what was being litigated in yesterday's case had nothing to do with the exclusion of evidence. Yesterday's ruling surprised us all and, in fact, made a holding with respect to Officials Act evidence. This really puts this squarely at issue in this case. It's not a frivolous motion.
Now that you've had a chance to digest it, I know yesterday we were reading through it with quite a bit of haste as it came down. But, I've had 24 hours, you've had 24 hours. Now that you are looking at it, does it seem as dire a decision, as consequential a decision as it did in those immediate moments?
Yes, because formalistically, it is a partial immunity decision, but read in its totality, it is functionally an absolute immunity decision. Between the categorical absolute immunity for core constitutional functions of the presidency, the fact that you can't consider a person's motive in weighing what is and is not an official act, the fact that you can't use official acts evidence, and then the presumption of immunity, at least, the court says, at least, we're not resolving it now, but at least we'll give you the presumption of immunity for any other official acts. That, to me, is, as I said yesterday in a tweet, not a thumb on the scale, a full handprint on.
Was this a defense attorney's dream? A defense attorney for a president of the United States?
It was so much more than I think any of us expected. Because when we were here at the oral arguments before the Supreme Court, there was definitely going to be some distinction between official acts and conduct that falls outside of that. That became very clear. But to your point, it's so spot on. The fact that this extended to that evidentiary preclusion issue, that evidence, even if the conduct isn't charged, none of the evidence can come in for official acts evidence with respect to setting the stage or showing the conduct or speaking about motives or anything that you would actually need in order to establish a case as a prosecutor. So that really took the wind out of the sails as far as a prosecution is concerned.
Justice Amy Coney Barrett disagreed with that.
Thinking about that. She said, I joined the dissent on that issue, that, jurors should not be blinded to the surrounding circumstances of what the defendant's conduct. Basically, they're saying, the majority, you can't bring in any motive evidence, which you're always allowed to bring in a criminal trial. It's not necessary. The prosecution generally doesn't have the proof motive, but you're generally allowed to bring that in, but not for, as Lisa said, for a president of the United States, because the president is clearly above the law, at least according to this majority.
Vaughn, I want to get the practicalities from you in a moment, but I want to ask one more question. So, and this is how I read it. You tell me if it's wrong, because you guys are legal minds, and I am just, playing one on television. I read it as you can use they're reading the Constitution as saying it implies an authority or implies immunity to a president, so much so broadly, that even his motivations can't be questioned if he were trying to violate the Constitution. So it was circular. Is that an incorrect reading of it?
No, I don't think so. I think there are a lot of things about this decision that are sort of tautological, and there are a lot of things about it that are just simply illogical. You know, to point out, pick up on Catherine's point about Amy Coney Barrett and her concurrence in part, she drops a footnote saying, like, it's lost on her why the fake elector scheme, for example, could plausibly be official, that the president has no role whatsoever in the administration of federal elections. To her, there's no analysis that needs to be done. She says squarely the fake elector scheme in its totality is private conduct. But that's not how the majority sees it, despite admissions from Trump's lawyers at oral argument.
Are they saying that the Constitution protects the president allows the president to violate the Constitution?
Well, put that way, yes. Basically, he has absolute immunity for his core constitutional function.
So I'm the president, so I can do what I want, even if I'm trying to violate the Constitution, which is what Donald Trump was accused of doing in 2020.
When the president does it, it's not illegal. I mean, if you go back that far.
It's hard to square. All right, Fawn, practically speaking, from your reporting, the conversations with Donald Trump and his campaign, the people surrounding him, what would he want to do with authority like this?
Number one, Donald Trump has said over the last year that he would want to investigate Jack Smith. He has said that in a social media post that Liz Cheney, there should be a military tribunal. And I keep coming back to this, and I know this is obnoxious here, but this is a formal messaging of...
This is his words.
He reposted, and I think we can zoom in on this. He posted just yesterday morning these images, and this individual wrote, "They should be going to jail on Monday, not Steve Bannon." Those individuals include Mike Pence, Mitch McConnell, Nancy Pelosi, Joe Biden, Liz Cheney. Those are the words of Donald Trump, and I think you have to take him seriously. He would have 4 years in office. He has suggested that he should seek investigations into Biden and its affiliates. And so on its face, with the Supreme Court ruling, we have no choice but as reporters to take the words of him seriously and to
the investigators.
And it's not just a presumption of immunity when it comes to investigations and prosecutions. The majority decision says very squarely that investigation and prosecution are squarely within the authority of the executive branch. They count as core constitutional authority in the same way that a veto or a pardon or removal or appointment of executive officers do. That places this squarely in the heartland of absolute immunity, as opposed to just the presumption of immunity applied to all other official
Justice
acts.
Roberts calls this all, and it's not the word that he used, but he implied that this sort of reasoning is all hysterical.
The President of the United States appoints the 93 United States attorneys throughout the country and Puerto Rico and Guam. They have a lot of power. Who do they work for? The Department of Justice, the Attorney General. So this decision said, basically, the President of the United States can weaponize the Department of Justice. He has absolutely